Here in the plea of Andrew Gabriel against Phillip Edwards Alexander.
Good afternoon.
Good afternoon, Mr. Mendes. Just before you begin, can I just check that, Mr. Armourer, you're able to see and hear us all right?
I confirm that I can see and hear you all. Yes.
Thank you. And we can see and hear you very clearly as well. Fine. Mr. Mendes.
Thank you very much, my lord. I'm here on behalf of the appellant, and I'm leading Mr. Clay Hackett. And of course, Mr. Gregory Armour, my learned friend, appears on behalf of the respondent. My lords, my lady, one of the main issues on this appeal has to do with a difference of opinion between the trial judge and the Court of Appeal as to the meaning to be ascribed to the words that were used by the respondent in what has been referred to in the proceedings as the first statement.
Yes.
And that was a statement that he made during the course of a radio program.
Yep.
And that the video of his delivery on the radio was then posted on his Facebook, and it found its way in various social media and so on. The transcript of what he said is in the agreed
Yes,
statement.
we've read it.
You've read it, much obliged. If I can just point to a couple things that was said that he said by way of explanation, to the extent that certain local slang may be used, or words may be used that may not be readily apparent to my lords and my lady. The second paragraph, I'm referring to page 1453,
Yeah.
which is in the statement of agreed facts. He says, I want Andrew Gabriel, don't send CPEP Syrians to me. CPEP is an acronym. It refers to a government employment relief program. You come, brother, let me and you discuss how Norman Gabriel Insurance Brokers went from a 2x4, again, that is West Indian slang. It refers to something that is small or insignificant. A 2x4 with a T and Tech, what it is, what all you get, the pension fund. So this is, your company has moved from a small, insignificant company to the point where it now has the TNTEC's pension fund. TNTEC is the Trinidad and Tobago Electricity Commission, which is a state corporation that delivers most of the electricity in the country, in the Twin Islands state. And then he goes on to say...
what have they got to do with it? Sorry? What's the suggestion?
The suggestion is that the company, Norman Gabriel Company Limited, got...
That size, to that size of company?
Went small, from a small company
Yeah.
to getting the pension fund with TNTEC.
You can have your pension fund with TNTEC?
Well, TNTEC has a pension fund for its workers.
I see. So a pension fund like TNTEC?
No,
No,
TNTEC...
it's managing their pension funds.
Essentially, yes. The TNTEC is a company. It employs, obviously it employs people.
Right.
And there's a pension fund for the employees.
So Norman Gabriel is
Insurance
Gabriel's,
brokerage company.
Yeah, right, and they are now got the job of managing the TNTEC
Pension fund. Yes.
But they're insurance brokers. They don't manage pension funds.
Well, that is one of the issues, of course, and I'll come to that because the Court of
Right.
Appeal does make reference to
Doesn't
that.
make sense to me.
But it may not necessarily be managing the pension fund. Insurance brokers may also shop around for a pension fund for a company, getting the best rates, getting the best benefits, and so on. But I'll come to that in a moment.
I'm afraid, to be perfectly frank, I mean, very often the cases that come to us in the Privy Council, I think we're in reality as well equipped as anyone to deal with them. But that is not the position here. We almost need a translation of this. I mean,
Yes.
for example, he talks about your Spranger Piper.
Yes.
I have no idea what a Spranger Piper is.
Exactly. Well, again, Spranger is local parlance for somebody who is homeless, who's living on the streets. A piper would be somebody who is a drug addict, maybe. So that those are the types of...
Right. So Spranger Piper is a homeless drug addict. Right, well, that rather demonstrates the point.
Yes, it does. It certainly does. So he's saying, so the point that we make, I'll come to the meaning in a moment, but I'm just saying, he then says, he's calling on Andrew, phone him up, he's telling him to pull off Spranger, Piper, Dane Wilson from Phillip Tail. Phillip, of course, he's referring to himself, and Tail means he's basically saying, stop him from harassing me.
Right.
Tell him pull off CPEP Syrian George Elias from Phillip Tail, because I will put information in the public space and you all will have to go home and pack up and leave. Yeah. So our case is, and of course this is the case that the learned trial judge accepted, is that the ordinary listener who would have the opportunity, of course, to replay this program if they wish to do so, and it was being shared, would, first of all, understand Mr. Alexander to be saying that Norman Gabriel, the Norman Gabriel Insurance Brokers, the company, went from a small company to the point where it now has the pension fund portfolio at TNTech, which is a large state corporation. And that he is saying to Andrew Gabriel, come, let's speak about this. And then he's telling him, if you don't pull off Dane Wilson and George Elias from harassing me, from all of these posts they were making. Sorry?
Who are Dane Wilson and George Elias?
These are persons who Mr. Alexander is saying were blogging themselves and criticizing Mr. Alexander, saying things about Mr. Alexander
Are
that
they
he didn't like.
politicians or just...
No, they're not politicians. They would be ordinary citizens making use or misuse of social media.
And I think Mr. Alexander thought Mr. Gabriel had put them up to...
He thought that he was of the view that Mr. Gabriel had put them up to it. Mr. Gabriel denied it,
yeah.
And there was never any evidence put before the court that he was behind them at all. But he's calling up, he's thinking that Mr. Gabriel was behind it, turns out falsely, and he never attempted to prove it at trial. And he's saying, call them off, or I'm going to put information in the public space that would cause you to pack up and run away. So that we say that the ordinary listener would be asking the question, well, he wants to speak about how this company moved from a small enterprise to a big enterprise. It became wealthy, as it were, because it now has the state corporation's pension fund as part of its portfolio. And Mr. Alexander is saying, well, he's going to put information and it will cause Andrew Gabriel to pack up and leave the country. So we say that the ordinary listener would ask the question, well, what is the information that Mr. Alexander has? They would think, and the impression that they would form immediately, it is information relative to how the company was so successful, or became so successful, moving from a small company to something with a large portfolio. And they will say, well, what sort of information will cause Andrew and his family to pack up and leave Trinidad and Tobago? They will, of course, say to themselves, well, it can't be information that shows that they were great businessmen, or Andrew Gabriel was a good businessman, and therefore that is how the fortunes of the company were improved. It has to be something negative, because if it was something positive, then he would not be minded to pack up and leave. So the impression that would be left on the person listening to this is, well, there's something negative. At the very least, it's something negative. They would also think, well, what would cause you to pack up and leave the country? If it's something that is embarrassing, your reaction might simply to be, well, I'll stay home and hide myself away from persons so that I don't have to encounter people. But it's more than that. It is, you will pack up and leave. You will leave the country. And the impression, certainly we're respectfully submitting, that would be left on the ordinary listener is that it must be something that is very serious. It must be something that is criminal in nature. And having regard to the fact that the information, or the suggestion is that the information has to do with the success of this company, It must be that they did something untoward, something illegal maybe, that resulted in the company enjoying these fortunes, getting the pension fund at T&Tech. Now,
I don't think we've got sim and stretch in the bundle, but the classic test, Lord Atkins, is whether what is said would tend to lower the plaintiff in the estimation of right-thinking
Yes.
members of society generally. And you say if you imply that you hold information about someone which, if revealed, would necessitate him and his family having to flee the country,
yes,
then that's a statement which will tend to lower the individual in the estimation of society.
yes, essentially. This is what we say. And of course, the trial judge agreed with us, and we respectfully submit that it certainly is one reasonable interpretation of what was said, and it would fall within the range of reasonable interpretations. And if it does fall within that range, then there was no basis for the Court of Appeal to overturn it. Now,
when there were juries, at least in this country, for defamation trials, it was a question of law for the judge,
yes,
what meaning the words were reasonably capable of bearing, and then it was a question of fact for the jury, what meaning they did bear.
yes.
On a quick look, I can't see whether that distinction's still drawn now that judges decide in this country, presumably as they obviously do in Trinidad,
Yeah.
but I see no reason why it would be any different. What do you say that the proper test is on an appeal?
Well,
I mean,
it is the same test we say, that it is a question of fact determined by the trial judge. Yeah. And we have referred to the authorities that indicate that it is a determination of fact whether what has been said would be interpreted by the ordinary person as being defamatory. It is a finding of fact, and therefore the normal test applies when that finding is being reviewed on appeal. It's either an error of law that you identify, or that it is plainly wrong, which is what the Court of Appeal found in this case, that the interpretation by the trial judge was plainly wrong. But we respectfully say that if it falls within the reasonable range of possible meanings, then the Court of Appeal ought not to have overturned it. As a matter of fact, we respectfully submit that is the trial judge's meaning was in fact the only meaning that could be ascribed to what was said by Mr. Alexander, and that the meaning that the Court of Appeal put on it was really a very strained meaning. And I will ask you to look at it, of course, immediately as to exactly what it is that the Court of Appeal said. Now, first of all, in referring to the question of the growth of Norman Gabriel Brokers Limited, the Court of Appeal thought that part of the statement by Mr. Alexander was intelligible, that it had no meaning in fact. And I'll ask you to look at paragraph 26 of the judgment. You'll find it at electronic page 1360.
Sorry, this is the first instance judgment.
No, this is the
Court of Appeal.
Court of Appeal. So the Court of Appeal first discounted that part of the statement as being meaningless. You see paragraph 26 says, even the statement that let you and me discuss how Norman Gabriel Insurance went from a 2x4 with a T&Tech, what it is, what all you get, the pension fund, etc. He says it would be understood by him to be barely comprehensible and without more detail actually meaningless. Any impressionistic view or implication that this was suggesting corruption would be countered by the fact that the linkage between the respondent's named insurance brokerage firm and a pension fund would make no sense to him based on that statement. Even the ordinary reasonable person in this country would understand that even the suggestion of unusual growth by that insurance brokerage when linked to a pension fund makes no sense, because an insurance brokerage firm would not normally provide either brokerage services or trusteeship services to a pension fund. The ordinary reasonable person would appreciate that Not every word in this lengthy broadcast necessarily carried any meaning, and those words certainly did not. So Justice Rajkumar is attributing to the ordinary reader the knowledge of what services an insurance brokerage firm might provide. Now, there was no evidence before the court at all as to what services brokerage firms provide. That issue just simply never arose. And to the extent that Justice Rajkumar may be giving judicial notice to something that is notorious, again, there was no indication that the Court of Appeal was going in that direction, so that there was no engagement with my client in the court below as to whether this was a notorious fact. Now,
well, it is pretty hard to give the words a specific meaning, but the general gist of it seemed to be it went from a small company to a big company.
That's basically what it
Well,
means.
I think it's saying they were a very small company, but somehow they managed to get one of the biggest pieces of business that's going.
That's essentially what it is. And you'll see in the cross-examination of Mr. Alexander, that's basically what he was saying. Time and time again, he's saying, that is what I am interested in finding out. How did Norman Gabriel move from a small company to this big company that it is now? Now, of course, what he thought and what he's saying in the cross-examination is not of assistance to the exercise that we engaged in.
But that, you say, shows that was the meaning he was trying to get across. Whether or not he succeeded, as the Court of Appeal says he didn't succeed.
Yes, basically that's what he was doing. But in relation to that observation made by Justice Rajkumar, it is puzzling, because if you then look at what he says at paragraph 40 of his judgment, which is at page 1365, he says, for many of the 16,000 followers of the appellant, the respondent and his company would not be a familiar name. The company is simply not that widely known. So again, he's saying it's not widely known, but nevertheless he's saying earlier on that everybody would know that this company would not be engaged in any business with a pension fund. And then at paragraph 50, he says, this is at page 1369, the appellant denied that this referred to the respondent at all, because the respondent explained, or he explained, did not have an insurance company, but rather an insurance brokerage company, a distinction that would probably have been lost upon the reasonable, objective, casual reader of a Facebook post. So he's accepting here that the ordinary reader of a Facebook post would not know the difference between an insurance company and an insurance brokerage company. So that when reading reference to Norman Gabriel Insurance Brokerage Company, presumably in the statement that we are concerned with, the casual reader would not know the difference, would not know that it is either insurance or insurance brokerage. And then later on at paragraph 53, at page 1370, he says, with respect to the fifth statement, the appellant contends that he's referring to an insurance company. Although the respondent's insurance brokerage company is not strictly an insurance company, the reasonable objective reader would hardly make that distinction, especially given that the renewal of insurance would more likely be done through an insurance brokerage company rather than a single insurance company. So again, confirming that in the courts, in his view, the ordinary reader would not know the difference between the two, and presumably therefore would not know of the difference in services provided by an insurance company as opposed to an insurance brokerage company.
Yeah.
And in that regard, my lords, my lady, we have taken the trouble to, because of the fact that the court apparently took judicial notice in the earlier paragraph of what ordinary readers would know the services offered by an insurance brokerage company are, we have sent to the registrar what do they call it? Not Facebook pages. The websites of 3 brokerage companies in Trinidad and Tobago, M&M Insurance Brokers, Agostini Insurance Brokers, and another insurance brokerage company. 3 of them. CIC Insurance Brokerage Company. And on their websites, they all offer services relating to pension funds. Now, it could either be, as I suggested earlier, that you would go to an insurance brokerage firm if you wanted to set up a pension plan for your employees, and then the brokerage firm would shop around for the best deal, as it were, from other insurance companies. Or a brokerage firm may manage the pension plan itself, if not being trustees of the pension plan. So that the point is that if the issue had been examined at all, then this sort of evidence could have been put before the Court of Appeal to indicate that there is no accepted, notoriously accepted fact that insurance brokerage companies don't provide any service in relation to pension plans.
Yes, thank you.
Well, yes, it's a different thing whether they're providing them to the public or whether they're providing the services to the pension provider.
Yes.
Yeah.
Yes. But and in this instance, what the impression that you're getting from what Mr. Alexander is saying is that Norman Gabriel Insurance Brokerage got something.
As a matter of fact, does Norman Gabriel Brokerage actually have a contract with TNTC?
No, they don't.
They don't?
No. And that was brought out in the evidence. Mr. Gabriel says he's had no contracts. It was another company that he had, state agency, the National Housing Corporation, NHC. And as a matter of fact, you will see in Mr. Alexander's summing up, which he did himself, he accepts that he made a mistake. It should not have been TNTEC. He should have put NHC in his statement.
Well, I'm not sure it's capable of too much analysis, what he said, anyway.
No.
I mean, it's pretty garbled, but you get some general sense from it.
Yes. Yes. Now, the Court of Appeal thought that there was no, the ordinary person would not think that there was anything defamatory about what was said, that there was nothing in it that would lower Mr. Gabriel in the eyes of the ordinary citizen of Trinidad and Tobago. And their reasoning appears in 4 paragraphs, basically, paragraphs 18, 19, 23, and 24 of the judgment. And you will see those at pages 1357, paragraphs 18 and 19, and then 1358 to 1359, paragraphs 23 and 24. And if I may summarize what was being said, the court was saying that the ordinary listener would appreciate the following things. One, that what was being made was a threat to disclose information, and you'll find that at paragraph 18. 2, that the threat to disclose information was conditional on Mr. Gabriel restraining his attack dogs, my words, in inverted commas, and you'll see that at paragraphs 19 and 24.
Well, the conditionality is in paragraph 18 as well. I mean, that seems to be the major theme, that nothing's happened yet. It's all conditional.
Exactly. And as a matter of fact, because it was conditional, it may not have been revealed at all, which is another of the points that was made. The third point was that the information was not particularized, which is at paragraph 18. The other point is that the information was not revealed, that is at paragraph 19, that the information may never be revealed, that's paragraph 19 and 24, and of course it may never be revealed because it was conditional. The other point was that until the information was disclosed, it could be a bluff, which upon disclosure might prove to be unsubstantial. So he's saying that the ordinary reader would appreciate these things, and that again is at paragraph 19. Justice Rajkumar says further that the ordinary listener, reader, would understand that the seriousness of the information, its meaning and its impact could only be assessed when it is revealed. He says that at paragraph 19. The ordinary readers would also appreciate that upon disclosure, the information may turn out to be damning or an empty threat, one or the other. And that point is made at paragraph 23. The ordinary reader would appreciate that it was only upon disclosure that he or she could determine whether the information was so serious as to cause the Gabriels to flee. That's at paragraph 19. He therefore says that the ordinary reader would, in those circumstances, withhold any opinion until the information was disclosed. That's at paragraph 23. And his conclusion, therefore, was that it was speculative to conclude that the information which the respondent threatened to reveal referred to corrupt or criminal activity. So for all of these reasons, he's saying, well, it's essentially what the appellant or the respondent was asking the court to do was to award damages for anticipatory defamation. That's a phrase that was used.
He doesn't seem to be applying the right test here, because he's undertaking the exercise as though he was the judge.
Well, he's not asking the question, what would the ordinary reader think the respondent meant?
But that's not the question for him anyway. That's the question of fact for the judge.
That is a question of fact for the judge. And the question for him is, well, is that interpretation by the judge one of the, or fall within a range of possible interpretations?
Yeah.
Equally, whether the information, if revealed, would actually be so serious that the appellant has to leave the country is again, that's an error of approach, because whether it's defamatory doesn't depend on whether it's true.
No.
The question is whether what's actually said would lower the person in general repute.
So, my lords, I thought it might be useful to try to test the approach of the court by asking this question. If what Mr. Alexander had said was, if you don't cease your attack on me, I will disclose information to the public which will show that you are corrupt. Now that is conditional. There are no particulars stated. The information is not yet revealed. In other words, it will fit all of the criteria set out by Justice Rajkumar, but it's being made clear the information is going to show that you're corrupt. Is that anticipatory defamation as
so you would say it's not anticipatory, because what he's saying is that he knows now of information as to what Mr. Gabriel has done in the past,
Exactly.
which, if disclosed, would...
He said, I'm presently in possession of this information. It's not the information that is going to come to hand. He's commenting on the nature of the information that he has. And he's saying, that information that I have, if revealed, will cause you to pack up and leave. So it's not speculation as to some information that might come into being at some point in time. It is a commentary by Mr. Alexander himself on the nature of the information that he has. And I'm saying it is no different if he had said that information will show that you are corrupt, or that information will show that you are dishonorable, or that you committed a crime, or that you took a bribe, or that you are part of a bandit clan. That is what he said. If I reveal this information, it will show that Mr. Gabriel is part of a bandit clan. Now, I'm using that phrase because the Court of Appeal found that the use of that phrase itself in the second statement was in fact defamatory. So if he says all of the things, I'm conditionally going to reveal information that will show that you're part of a bandit clan, the fact that it's conditional, does that mean that the ordinary reader will say, well, I'm going to wait and see if you actually disclose that information. You may or may not disclose it. When you disclose it, it may or may not show that, that Mr. Gabriel is part of a bandit clan.
Does that phrase have any particular slang meaning, or?
I'm not aware of a particular slang meaning, but it certainly was, it was interpreted by both the trial judge and by the Court of Appeal as having a defamatory meaning.
The points made may go to the extent of the harm or the amount of damage that the statement was capable of doing.
Yes.
Because you might attach less weight to this kind of threat than you would if some more specific defamatory statement had been made.
Yes.
But that would be a question, wouldn't it, of how much harm it had caused and what the damages should be.
Yes. And then, of course, the trial judge would assess that and would make an award to suit. But, of course, in this particular instance, the ordinary reader would be able to assess the nature of the information that is being threatened to be disclosed, not only by the impact that Mr. Alexander is saying that it's going to have, that is he will pack up and leave, but by reference to the thing that he wanted to speak to Mr. Gabriel about. How did your company become so successful? And the ordinary listener will say, well, particularly in Trinidad and Tobago, you got a contract from the government, well, it's some sort of shady deal you entered into there. And that is going to the integrity of Mr. Gabriel as a businessman. It is alleging dishonesty, as the Court of Appeal found in relation to the bandit clan reference. And therefore it is of a serious nature, but it is for the trial judge in those circumstances to assess what would be adequate compensation in having regard also to the evidence of the injury that is suffered by Mr. Gabriel. And of course, in that regard, excuse me, there's extensive evidence by Mr. Gabriel as to what he experienced afterwards, with a number of people asking him about it, asking him, well, what is the information that Mr. Alexander has on you? His mother gave evidence about the impact that it had upon her. She was not cross-examined at all on her statements, and she went into detail as to how it affected her and her family socially, and the children who were being questioned about it at school. What does Mr. Alexander have about your father? And of course, the embarrassment that they would feel, and as a damages not being awarded for the injury to their feelings, but Mr. Gabriel feelings that he has to now deal with a family who is experiencing the effects of what Mr. Alexander has said about him. So,
sorry, Mr. Mendes, before we go on, I'm sorry, I have to raise a completely unrelated matter with you. I need to keep track of the timetable of this hearing.
yes.
I don't know if you have in front of you the
Yes, I do.
document we have. It can't be correct.
Oh, I see.
Can I just check with you? How long do you think you're speaking for?
Well, I should be complete, I think by 2 o'clock. I just have to go through.
Well, I'm not putting you under any pressure at all. It's simply that
We have until 2:30.
This timetable has us finishing at 4:05, which
Yes.
is rather earlier than I thought we were. And
Oh, I see.
it.
No, we were scheduled, but this is in accordance with the times that we gave the registrar.
Right, and it allows the respondent.
Well, respondent to speak simultaneously with you, according to this.
Yeah, yes, there's certainly at least one mistake, but it only allows the respondent 45 minutes.
Yeah, that's all he asked for.
That's correct, is it?
Yes.
Okay, fine. Thank you. That's clear.
Thank you very much. So that,
And sorry, I just wanted to check, before we leave the first statement, we see at paragraph 24 in the Court of Appeal the reference to the I will put your business in the road. Can you just help us? Does that have a particular slang?
well, yeah, it just simply means that I'll make it public.
Right.
Oh.
Okay.
Oh, I thought it was.
I thought it meant putting it out with the rubbish or something.
No,
Yeah, I must admit that's what I thought.
No,
but
it
just means making it
make
public.
it public.
Oh,
Yes.
okay.
Right. Okay. Yes, thank you.
I can't claim to be up to date on the young people's slang, so I know Mr. Hackett is right.
Well, you may be in a slightly better position than we are.
I'm sure he'll correct me if Mr. Almore is in my age group as well, so we might both have to depend on Mr. Hackett to update us.
Right.
Right. Yeah, I have to say that does chime with what is said at paragraph 24.
Yes, I'm sorry, I'm so accustomed to the expression that I didn't think I needed to,
No,
to update
thank you very
all,
much.
but
That's
it's,
helpful.
It is slang, it appears. Yes, so that we respectfully submit, Your Honours, sorry, my Lord, that, I'm sorry, I refer to the judges of the CCJ as Your Honour, so excuse me. So we respectfully submit that the Court of Appeal was wrong to find that the trial judge was plainly wrong, in which case they were wrong to overturn her decision on that finding. They agreed with her that the second statement, the Bandit Clan statement, if we can make that reference, was defamatory. They disagreed with her as to whether that reference, the Bandit Clan reference, was in respect of Mr. Gabriel's family. That is to say, the family was the Bandit Clan, as opposed to other persons who Mr. Alexander thought were the financiers of the PNM, the People's National Movement. So there was a disagreement on that, but there was no disagreement on the fact that the statement is defamatory. So if the correct result of this appeal is that the judge's decision on the first and second statements are upheld, then we respectfully submit that the decision on the quantum of compensation ought also to be upheld. The Court of Appeal's criticism of the award was proceeded on the basis that the first statement was not defamatory, and they found that in relation to the second statement that the award should only be nominal damages of $10,000. And they reasoned that because the first statement was not defamatory, and you couldn't discern exactly what damage was attributable to what statement, that in the circumstances an award of $10,000 was adequate. We respectfully submit that if the trial judge's award is upheld, then her award for compensation ought also to be upheld. On the other hand, our position is that as far as her award of aggravated damages is concerned, she, as part of her reasoning, she had found that each of the other 9 or 7 statements were or had defamatory meanings of Mr. Gabriel, and on that basis she made the award of $225,000. The Court of Appeal has found that the other 7 awards were not, the other 7 statements were not defamatory, and in those circumstances, her...
Do you accept they were entitled to intervene there because she actually didn't really give any reasons for saying that they were defamatory?
Precisely, yes. And in those circumstances, we say that her award on aggravated damages can't stand, but that the order that we'd ask is that it be sent back to the Court of Appeal so that aggravated damages can be assessed.
Why do you ask us to send it back to the Court of Appeal rather than to the High Court?
That would be the ordinary thing that is done, but it would make sense to the Court of Appeal judge is still sitting. Not near it. Yes, no, Justice Gobin is still sitting in the High Court. I was just inquiring whether she is near retirement. But she's still sitting in the High Court, so that it would make sense to send it back to her.
So although you're not asking for us to look again at any of the statements other than number 1 and I think number 9.
Number 9, yes.
Number 9, though it's sometimes called number 8. But
yes.
So it's only the 3 statements that you're relying on as being defamatory, those
yes.
2 plus number 2.
Yes.
but you say that you are entitled to an award of aggravated damages, but you don't seek to uphold the judge's quantification of that because she added in all the other statements,
That's
but
right.
you say it needs to be re-quantified.
Well, she could take them into account, but what she did was to make a finding
Yes.
without any reasons that they were also defamatory. And she would now have to reassess the aggravated damages on the basis
Of just
as
the
found by the
three.
Court of Appeal. Exactly, yes.
But also, I mean, in relation to the judge's finding of the damage associated with the first and second statements,
Yes.
I mean, the Court of Appeal's criticisms range more widely, don't they? I mean, they say she didn't sufficiently take into account the conditionality of the statements and the way in which your client's reputation had been fully vindicated through the trial process. I think are points that they make.
That's one point. They also make a point that although she mentioned some other cases, she made no real attempt to assess where it fell in the scale of awards. And on the face of it, in what was one remark in the course of a 2-hour broadcast and a Facebook post, she had awarded damages that were right at the top of the scale of any case referred to in one. And so the damages were, well, A, not sufficiently reasoned, and B, manifestly excessive.
Well, my lord, of course there is always the question as to exactly what, or the extent of the reasons that you expect of the trial judge. She did say that she considered the range. We have to assume, therefore, that she looked at the cases and looked at the facts and looked at the awards that were made in relation to those facts, and then she made her assessment in comparison to them. She didn't go on and say, well, this is what was decided in this case, having regard to this particular defamation. It is or is not as serious as the one that I am considering. She didn't engage in that process, but we'll have to assume that that is what she did in coming to the conclusion as to exactly where in that range the award that she made fell. And the other thing is, of course, that she did take into account the evidence that had been put before her as to the impact of the statements on Mr. Gabriel and his family, and the injury that he would have suffered, viewing his family in pain, as it were, including his wife basically withdrawing from social life, and so on, and the impact on his mother and her reputation, and so on. She took all of those things into account in making her decision. As far as the condition...
Sorry, just on that, I mean, that, as I understand it, was very much bound up with the meaning of bandit clan, whether it's a reference to the family,
Whether it is a reference
which
to the
we've
family.
still got to look at yet. But if the Court of Appeal were right that bandit clan did not refer to the family, then
Yes.
that again would be a valid criticism of the judge's quantification of damages, wouldn't it?
It would be a valid criticism, but I'm not too sure how far that can be pushed in saying that the damages have to be reassessed, because the first statement was referring to the family. And
But I'm not quite sure what the significance is, because the family weren't claimants, were they? They weren't claiming. Other members of the family weren't claiming to have suffered damage. It was only
Mr. Gabriel, yes.
Mr. Gabriel, wasn't it?
Yes, but
So it's only his damage that we're interested in. The fact that other people in his family were defamed, they may have been, but they're not claimants. You're saying that knowing that bad things were said about them made it more upsetting for him, as I understand.
that's basically it. But my point is that they were upset from the word go, that is, from the first statement. They were being caused harm, not from the second statement, the bandit clan reference, which they thought was a reference to them, but from the first statement, which called Andrew's mother by name, Rosalind, which called his father by name, Normal, which calls his sister by name. All of them were referred to in the first statement. and that information would be put in the road that would cause them to pack up and leave. So he was suffering because they were suffering, and I don't think that his level of suffering, we can't quantify it, that it became more intense as a result of the second statement and so on. So I'm saying while the judge can be criticized for the finding in relation to the second statement that it referred to Mr. Gabriel's family, as far as the assessment of damages is concerned, I don't think that correction, let's put it as de minimis, I don't think it would be a cause for referring the matter back for an assessment, is my respectful submission.
And just in relation to your submission that if we accept that the first and second statements should be upheld as defamatory as the judge found them to be, and therefore we should uphold her award of damages, I think the other area of criticism by the Court of Appeal is that she didn't take sufficiently into account the constitutional context and significance of political speech. And so what do you say about that?
Well, she, as a matter of fact, she, right through her judgment, she makes reference to the importance of freedom of expression. She was aware of it, and she was also commenting on the submissions made by Mr. Alexander himself that he was exercising his right to free speech. And she made the point that that free speech, the right to free speech ends where the law of defamation begins.
Well, that's perhaps a not entirely accurate way of putting it. We've certainly had cases in the UK where even where there has been defamation, the right to freedom of expression has operated to moderate the amount of the damages on the basis that awarding an excessive amount of damages would have a chilling effect on people's willingness to express their opinions in the future.
Yes. Appreciate it. This case, of course, is one in which, although, and this is the point that the judge made as well, although there was a plea of justification, there was no attempt to prove it. And as a matter of fact, as I will refer you to in a minute, although Mr. Alexander maintained during cross-examination that he still had the information that he was threatening to reveal, and he still was characterizing that information as information that would cause Mr. Gabriel to pack up and leave, he never revealed it to the court. And as a matter of fact, he was then saying from the witness box, he was offering to reveal it then.
But doesn't that go to aggravation? That goes to aggravated damages, doesn't it?
Yes, it
if
does.
your subsequent conduct is a matter of aggravating the damages.
That's correct. But the point I'm making is in relation to the freedom of speech point.
Right, but a chill effect is something not just affecting this individual, but having regard to the wider social environment. If people think, if I get very close to the boundaries of what is permissible, and I step one pace beyond that boundary, I'm going to be hit with hundreds of thousands of dollars of damages. That's going to mean that they steer further away from the boundary than would be the case if they think it's going to be tens of thousands. I'll step up to the boundary.
I appreciate that fully, and what I'm saying is that you will see from the trial judge's judgment that she was alive to the question of freedom of expression.
Could you show us that, if you're...
If I... could I ask Mr. Hackett just to turn it up, and I'll refer you to those passages in a short while. But the point that I'm making is that in relation to the failure of Mr. Alexander to try to prove that...
so you're saying this wasn't something where he was on the borderline because he had information, he tried to justify what he said. In fact, it turned out that it didn't justify it.
No.
There was no attempt to justify it.
There was no attempt. So really and truly, it's not really a freedom of expression case. And as was made clear...
It's not really a case of someone exposing wrongdoing that they genuinely think has happened, which is what you don't want to chill by definition.
Precisely. You don't want to do that. And this I'm saying on the facts of this case, and this is what the trial judge appreciated, that if this was an attempt by Mr. Alexander to actually ventilate a proper grievance that would be of the interest of the public, then you would have expected that he would have revealed the information that he said that he had.
But it goes a bit beyond that, doesn't it, the freedom of expression point? It goes to the fact that people in the political context, particularly when strong views are held and there's animosity between political parties and groupings, may engage in excessively robust speech, and they may cross the line into it making defamatory allegations, but still, in the general interests of the democratic process, one shouldn't come down on them with a ton of bricks when they do that.
And in that scenario, yes, you would not want the court to come down on them with a ton of bricks. But when in this scenario it is clear that Mr. Alexander launched this attack on the 8th of February because he believed, without any evidence at all, at least none that he presented to the court, that Mr. Gabriel was behind the attacks on him by other persons. And he admitted in cross-examination that that is why he launched this attack, because of that belief. So this was just basically retaliation. He may not have launched this attack at all if he wasn't of the false belief that Mr. Gabriel was attacking him through these intermediaries. So I'm saying that, yes, I agree absolutely, and I'm not pushing back on anything that my lords are saying with regard to the need to ensure that freedom of expression is not chilled by high awards by the court. But in this particular case, there's not really any indication that Mr. Alexander was genuinely seeking to express a point of view.
The Court of Appeal said, paragraph 106, that the award is out of line with the range of awards in equivalent circumstances. And in paragraph 113, they say that the award was extraordinary in the context of this jurisdiction. Are you able to help us in relation to those comments?
There is a more recent decision of the court that we referred you to. We referred you to it in our written submissions, in which the range of awards was also examined. And the total amount of 775 would have fallen outside of that range, but it did because of the additional amount for aggravated damages. But we've put that case before you. It shows the range of page. Sorry, the case that I'm referring to is the Moore 104 decision, and you'll see an examination of the ranges at electronic page 2139. And this is the Court of Appeal saying that an acceptable range for this type of defamatory remark would be between 300,000 and 600,000.
Yes.
And the difficulty that I had, my lord, with the Court of Appeal's judgment and when they were assessing the damages is that it did not appear to me that they were assessing the award made by the trial judge on the basis of a finding that both statements were defamatory. I understood them to be assessing it on the basis that there was only one defamatory statement, and that was the second one. So it was difficult to, for me respectfully, to understand them to be saying that, well, if she was correct that the first two statements were defamatory, then this is an award that only merits $10,000, because in effect that's what they said. So it doesn't appear to me that they were saying, well, if we are wrong on this, then $775,000 is too much.
Well, maybe, but...
aren't there two things going on? Sorry.
Yeah.
I mean, one is that they don't agree with the trial judge's finding of fact in relation to the first statement that it was defamatory. And so that is obviously going to have an impact on damages. But they also make a series of points which are critical, either expressly or impliedly critical, of the judge's own approach, even allowing that her findings of defamation were different from theirs in terms of the amount of damages that she awarded.
I mean, reducing the damages from 775,000 to 10, it's hard to say that that's justified by saying it's one statement rather than two. It goes a bit further than that, unless the imbalance between the two statements is absolutely enormous.
Well, they made it clear, though, that the award of $10,000 was only in relation to the second statement.
Yes, I know.
So that's made clear.
I know, but still, if they awarded damages for if they'd just been faced, if they'd found the first statement was defamatory, they weren't going to uphold an award of 775, were they? I mean, it's plain that they wouldn't have done.
Well, I agree with you. There is a suggestion that even if they upheld it, they may not have upheld the 775. But I'm saying that part of the judgment, in my understanding of it, proceeded on the basis that there was only one defamatory statement.
Yes, it did.
And therefore, it can't be a criticism of the judge's award in relation to the two defamatory statements. But I do take
well, in and of itself, maybe so. But we have a lengthy judgment which goes through a whole range of things, which, as I say, sometimes expressly, sometimes implicitly, do seem to be critical of the judge's approach, even allowing for the fact that she had found that there was more than one defamatory statement.
My Lord, I can't push back hard on that.
No.
The point is that you could, looking at the paragraphs in isolation, say, well, this is a criticism of the judge's approach generally. My difficulty, as I said, is that they appeared to be in proceeding on the basis that they were dealing with one defamatory statement. So it was difficult for me, in any event, to treat it as a criticism of an award in relation to the two defamatory statements.
There's quite a range of cases discussed in the More FM case, and the awards in cases concerned with allegations of corruption seem to be in the region of $500,000.
Yes. Yeah.
They vary, but 400,000, 500, 600.
Yes.
It's that sort of range of figure. I look at things.
But my Lord says, I say I'm not pushing back hard on the point that there may be implied criticisms of her approach.
Right. I was just picking up on your submission that you said, well, if we conclude on this appeal that the Court of Appeal was wrong to find that there was not the additional defamatory statement which the judge had found.
Yes.
That therefore the judge's awards of damages must stand.
Yes. And
it was really just to query whether that is correct.
Yes, I appreciate that. Yes, I appreciate that. But if it is that you think that the criticisms that have been offered by the Court of Appeal also applies to her assessment in relation to both statements, then that may justify sending it back for the entire award to be reassessed.
I see, and really, my reason for raising it was to see whether there was anything that you wanted to say against that, but it doesn't sound like there is.
Well, I've said what I wanted to say against it.
Well, but is there anything that you want to say that would assist us in working out what the correct award would be if the judge's decisions on which were defamatory and which weren't was reinstated, but we thought that there was merit in the Court of Appeal's criticisms of the overall level of damages that the trial judge awarded? Is there an authority that you could point us to that says, perhaps as my Lord the President was suggesting, this is the range which would be the correct range?
Well, other than the More FM decision that I've already referred to, which gives a range, no, her assessment certainly falls within the range. I imagine there may be there may be some who would say that it should be at the lower end of the range rather than the
Yeah.
higher end of
Yes.
the range, but then it would be a question of whether it is disproportionately
And the
high.
aggravation, the aggravating factor, remind me, was what in this?
The aggravation factor was the repeated statements, the campaign, as it were,
Yeah.
that was followed afterwards, which of course can still be taken into account. But she proceeded on the basis that all of the other statements were defamatory as well, or at least bore the defamatory meanings that were pleaded. So that, you might say, was an added factor in her determining that the additional amount of $225,000 was adequate. $250,000. And because of that error, this is why we submit that it should go back for reassessment on the basis, of course, of the Court of Appeal's assessment of those additional statements.
Yes, yes. I mean, the Court of Appeal very fairly pointed out that the damages awarded have to reflect the damage to reputation actually suffered in the particular case, and should be consistent with the range of awards made in other comparable cases, which we've now had reviewed by the Court of Appeal in the Moore FM case.
Yes.
So if we remit to the judge, she's in a position to assess what the damage to reputation actually was in this case, and to make an appropriate award in the light of the range that the Court of Appeal indicated in Moore FM.
Your Honours, sorry, my Lord, I'm not pushing back too hard.
No.
I am saying that that the Court of Appeal, in their criticism of the award that was made, was making the point that the hurt that Mr. Gabriel said he had experienced could not have resulted from the first statement, because the first statement was not defamatory. That's the first thing. So a lot of the evidence that he gave as to what he experienced as a consequence of the first statement, they were saying had to be discounted in assessing the damages. Including, of course, the fact that the second statement, which was the only statement that was defamatory, didn't refer to his family, so that he was saying that they had to discount that as well. So that was part and parcel of the criticism of the trial judge's assessment of, in total, $775,000. And this is why I say that if the court accepts, that the board accepts that the trial judge was correct on the first statement, then all of those criticisms fall by the wayside.
And so you add back in, as it were, both his hurt from the first statement and his upset at seeing his family so upset and his children teased at school. And so.
That's basically it, yes.
Yeah.
So that would be added back, and the judge took all of that into account in coming to her assessment as to compensation outside of the aggravating factors. So, yes. One of the references to the freedom of expression by the trial judge in her reasons is at paragraph 2, page 1073. She says, "I think it necessary at the outset to indicate, or rather to remind the defendant, that this case was not as he perceives it about truth, justice, and a better country for us all. There are cases that deal with these noble causes, but this is not one of them. It is not the first suit of this kind brought against an active politician such as the defendant, will surely not be the last. The case only confirms the limits of two important constitutional rights, the right to freedom of expression and the right to the expression of political views. And it has long been established that these rights are not absolute. They do not trump the laws of defamation." And
right, but I mean that doesn't seem to involve an appreciation on the part of the judge of the chill effect being brought into account.
I will double check it. I'll double check in the break. Lord.
In paragraph 3, she says the impassioned appeals about any other significance of the case in the current political environment or its impact on the future of our democracy are, I regret to say, misplaced and misguided. So that suggests he gave no weight at all to any.
But
He didn't think that there was any relevance.
yes, I don't recall her making a reference or saying to herself, checking herself by saying that I bear in mind the chilling effect in making the award, but nevertheless I say 525,000. But I will double check to see if she says that. She does say at paragraph 34, speaking out against corruption for transparency, accountability, and with a view to preventing a collapse of our democracy is a very good thing, and it is only to be encouraged. The need for campaign and party financing has been a long-standing issue. Citizens understand that unchecked and unaccountable political spending can pave the way for corruption. But the absence of progressive legislation does not justify hurling out unsubstantiated accusations of corruption against individuals on the basis of suspicion or what we regard as old talk. So that is paragraph 24. Again, 34.
But I mean, the same comment
Yes,
applies.
yes,
doesn't it? I mean,
I don't think that there's any statement to the effect in deciding what is the appropriate level of compensation. I take into account the possible chilling effect. I don't think that there's a statement to that effect, but Mr. Hackett will be checking to see if there's anything in that regard that I can point you to. Well, I think that is as much as I intended to say on.
Did you mention the ninth statement? Is that one you're seeking to uphold?
Would I just rely on my written submissions as far as I'm concerned? The simple point that we made there is that the Court of Appeal didn't take into account the words that were used, that what Mr. Gabriel was doing was raping the Treasury, and what those connotations were. But if I can rely on those.
so I think, can you just remind me where we see the ninth statement? Is that in the statement of facts and issues?
Yes, it would be.
Or is that what's called the 10th statement?
I think
On page 1458?
I think it was the 8th.
Oh, no, there's a 9th statement.
The court refers to it as the Court of Appeal refers to it as the 8th, but it is the 9th.
So it's the 9th one.
It is the 9th. We refer to it as the 9th. And
so is that paragraph 1.9 of the statement of facts and issues on page 1457?
I think it is.
Was this the 18th of March 2017?
No, sorry, from what I'm looking at, that's it. The 9th statement is the 2nd of April 2017.
Well,
I'm sorry. We refer to it is referred to, if I may, on.
I can't find it in the statement of facts and issues.
I thought it was the 8th statement. On the 8th.
It's the 8th. In the SFI, it's the 8th.
Yeah.
Yeah.
What's
It's the one that refers to raping the Treasury.
Oh, yes.
It's at page 1455.
Yep.
We're thinking it's the one designated as the 8th statement,
Yeah.
paragraph 1.8 of the statement of facts and issues, but if you could confirm that.
Yes, that is the one, yes, the 8th.
So that's what you've been referring to as the 9th.
I've been referring to that as the 9th. Yes, I'm sorry.
The 22nd of March.
Yes, and it says, members of the Syrian community would like Trinidad and Tobago to know that they are not responsible for this Keith Rowley government, nor for the handful of their members in the Rowley cabal. Many of them are ashamed and tired of being painted with the same brush because of the antics of a few. And I have to agree, stereotyping of a race because of the behavior of some of its members is unfair, but the questions I want to ask is minority government. With the lowest vote in our history, if the black community does not claim you and the middle class wants you to see the back of you, who is supporting you? Besides the group of material beneficiaries, who claims your ideology, who believes in your programs, besides the people who paid to say so on your finances, raping the Treasury, who supports this government? I think it is time to fire them and so on. So it is that part, the finances raping the Treasury. That,
And I'm sorry, I should have picked this up. The Court of Appeal number this give this what number?
They numbered it as the 8th.
8th,
But,
right. So 8th in the Court of Appeal and 8th in the Statement of Facts and Issues.
It is, yes.
Okay, thanks.
So you say that the members of the public would understand the reference to financiers raping the Treasury as being a reference to the appellant?
Yes.
And as to what? Corrupt conduct? Or what is the imputation said to be? I mean, he goes on to talk about them as incompetence. Raping the Treasury could just mean wasting public money, couldn't it? Or is there a pleaded imputation for this, meaning?
Yes, it was pleaded. The court rejected it because they were saying that there was nothing in the statement.
No, but what is the alleged meaning of it, though?
Sorry, Dollars, I didn't actually.
All right, well, we can look it up for ourselves.
I didn't prepare to pursue this in any detail at this stage, so I apologize for not being able to refer to it directly. But again, I'll ask Mr. Hackett to.
If you could give us the bundle reference at some point during the hearing, that would be helpful.
I apologize for that.
It's on page 19 of the bundle. Paragraph, the statement is in paragraph 26 of the statement of claim, and then paragraph 27 sets out the innuendo.
Yeah.
Yes, it does say there. The above words complained of in their natural and ordinary meaning and or by innuendo meant and were understood to mean that the claimant has brought shame upon his community, that the claimant who the defendant is repeatedly described as a P&M financier has engaged in acts including but not limited to raping the Treasury, and that claimant is involved in corruption and unjust gains at the expense of the National Treasury.
Okay.
And I'm so sorry, just to pin it all down. And the judge said what about that?
Nothing. Well, I said that just one line, but it bore those meanings.
So can you show us just so that I can see where she says that?
I think she just dealt with them generically, as far as I know.
Yes. Yes, she did.
Is it paragraph 31?
Paragraph 48.
Oh.
48 on page 1090. 48 says, I believe that a significant award of aggravated damage is warranted in the circumstances. I've considered defendant's conduct in relation to the subsequent publications, which substantially repeat the imputation of the claimant being a P&M financier who is together with his family benefiting from political patronage. I find the publications all have the meanings ascribed to them. And that's all that she says.
Right. But that is clearly her making a finding that she accepts the alleged meaning that has been pointed out on page 19.
Yes.
Yes. Okay. Thank you.
Yes, my lords. If I can just spend the 15 minutes that I have, I just wanted to offer some criticism of the, if I'm on the assumption that we are now at the stage where the only finding that of defamation that remains is the Court of Appeals finding. In other words, I'm assuming that you have not upheld the appeal in relation to the first one. So I'm now dealing with the aspect of the appeal against the award that is made by the Court of Appeal in relation to the second finding of defamation in relation to the second statement. And if I can just remind you of the findings that were made by the Court of Appeal in relation to the second statement. You see at paragraph 37, they say, and this is at page 1364, however, although the term bandit clan did not refer to the respondent's family, the ordinary reasonable reader would have understood that unfortunate term to suggest, by its linkage to party financing, that the respondent was obtaining benefits thereby in an unfair manner as a result of favors granted to him as a member of a bandit clan of party financiers. The ordinary reasonable person engaging in loose thinking, reading that post quickly, would form that impression. That is clearly defamatory. And then at paragraph 39, they say, it could hardly be contended that the reference to the respondent as a member of a bandit clan would not have tended to lower him in the estimation of right-thinking people in that context. In addition, the bandit clan would necessarily engender hurt feelings in someone who had an impeccable reputation, was managing a family-owned company founded by his father and bearing the family name. He would therefore be entitled to damages to vindicate his reputation and compensate him for hurt feelings as a result. And then, so that's paragraph 40. There's also a reference at paragraph 39 that I won't read to save time. And then at paragraph 105, the Court of Appeal says in the, that's page 1392, from the fifth sentence from the bottom. The sting of that libel comes from the use of the word bandit. The statement itself, though insinuating general dishonesty, is not sufficiently specific as to cause the ordinary reasonable reader to maintain any diminished view of the respondent, unless and until that general assertion was substantiated. In fact, it never was. So that they are accepting that that is an insinuation of dishonesty, but then they go on to say, well, it's not particularized and therefore you have to discount it, although of course they have already found that the statement itself would cause hurt feelings and that the claimant would be entitled to damages for the injury that is caused to his reputation. Now, my lords, we have dealt with this in detail in our written case, our criticisms of the Court of Appeal, and in the little time I have left, I wouldn't want to refer to everything that I wanted to refer you to. I just draw your attention to the Master of the Rolls, as he then was, Lord Bingham, in the John and M&N case, which we refer to at our paragraph 79 of our case, which is at 1494, which he says, I'll just read it quickly. A successful plaintiff may properly look to an award of damages to vindicate his reputation, but the significance of this is much greater in a case where the defendant asserts the truth of the libel and refuses by retraction or apology than in a case where the defendant acknowledges the falsity of what was published and publicly expresses regret that the libelous publication took place. It is well established that the compensatory damages may and should compensate for additional injury caused to the plaintiff's feelings by the defendant's conduct of the action and persists in an unfounded that the publication was true or refuses to apologize or cross-examines the plaintiff in a wounding or insulting way. And of course, earlier on, he refers to the fact that where a libel touches a person's personal integrity or professional reputation, honor, courage, loyalty, in other words, when it touches the core personality of a person, then it is considered serious, and the Court of Appeal is accepting that it is impacting Mr. Gabriel's core aspects of his personality, is impacting his honesty. It's saying that he obtained his contracts in an unfair manner, so on. They've already said these things. So our criticism of the Court of Appeal is for not appreciating that this was one of a serious one, that they also did not seem to appreciate the wide dissemination of the libel, which we touch upon in paragraphs 87, 88, and 89 of our case. And I'll also direct your attention to the evidence, that is Mr. Gabriel's witness statement, which you will find at pages 499 over to page 502, paragraphs 19 to 24 of his witness statement, in which he set out in detail the number of followers that Mr. Alexander had on his Facebook pages. And in fact, Mr. Alexander himself boasted that he had more followers than did the Prime Minister or the Leader of the Opposition. But what I wanted to bring to your attention in particular are the things that Mr. Alexander persisted in saying during the course of the proceedings. As pointed out, there was a defense of justification. which he never really sought in any serious way to support. But then during the course of cross-examination, he made a number of statements. I'll direct your attention first to page 964 of the electronic bundle, lines from line 2, and the cross-examination goes like this. Question, when you were publishing on 8th February, you had something in mind other than what Asher Javed had published. That reference to Asher Javed was to an article that had been published some months before. Correct? And he says yes. That thing that you have not revealed to the court as yet, correct? He says no. The question, no, you have not. And he says, would you like me to? And I say, that thing you have not yet revealed to the court is what you thought would cause Andrew Gabriel and his family to run, pack up, and leave. And he says yes. So up until this point in time, he's maintaining that he still has this information that is the thing that would cause them to pack up and leave, and he is offering at this point in time to reveal it to the court. On page 465, after he has made reference to what he refers to as the contractocracy, this is at page 965, line 23, I ask the question, what is the contractocracy? And he says the contractocracy is unethical lawyers, criminal and corrupt businessmen, public office holders who work together in conspiracy to get government contracts in hundreds of millions and billions of dollars to rob, rape, and plunder this nation's treasury. And I ask, and do you include Mr. Gabriel among the contractocracy? And he says, most definitely. And on the following page at 966, I say, and what I'm asking you, sir, is when you made those references to Mr. Gabriel as being part of the bandit clan, so this is now a reference to the second statement, you had this other thing in mind which you have not yet disclosed to the court, am I correct? And he says, correct. And then the judge at the bottom of that page intervenes for clarity. If I may point out that although Mr. Alexander began the case represented by counsel, when we came back for his evidence, he was not represented, and the judge was expressly, throughout the transcript you will see, exercising, giving him leeway to say things and also asking questions in order to give him the opportunity to explain himself. And she says, you haven't yet said anything or indicated anything, Mr. Alexander, so let's stick to this case. Counsel is asking you a simple question. So far, you seem to be saying that you accept that you were saying that there are other things, you haven't yet disclosed those things, and I'm not going to allow you to disclose any new things here under the protection of the court as a witness in the case. So the simple point is, you have not yet disclosed those things, but you did in a sense threaten that you had information which you would cause him to run, to flee the country, and he confirms yes. Later on at page 968, from line 23 at the bottom of the page, the judge asks him, in relation to the first statement, and she's quoting, I want you to know when I put your business out on the road, you and your family will have to pack up and leave. And she says, well, ordinarily, if you threaten me, Mr. Alexander, if you say, you know, this judge, when I put her business out on the road, she's going to leave, she will lose her work as a judge. That can only imply that you have something that is so serious an allegation about me. And he answers, scintillating, scandalous, yeah. And then the judge says, a corrupt, scandalous, salacious, that kind of thing that would cause me to lose my job, to leave my country. And he says, exactly. So he's confirming that this is the type of information that he has, and he still has, and he's offering to reveal to the court. And the judge was then asking him questions. So I was asking him questions about the statement that he made.
I thought there he's just being asked whether that was what he meant to say.
Yes, yes.
He's not reasserting it, is he? He's just agreeing that that was what he was meaning to say in his broadcast.
Yes, but earlier on he said that he still has the information and that if we wanted to reveal it.
Right.
So I'm just saying that he is characterizing the information that he has and still has and can reveal but was not revealing or had not yet revealed. And then you will see at he was being asked questions concerning a statement that he had made about the Syrian community and his disdain for certain Syrians, elements of the Syrian community. And at page 977 at the top of that page, he says, "Yes, Your Honor, but the matter for Andrew Gabriel wasn't because he was a Syrian. It is because he is corrupt." And that's two different things. On page 979 at line 9, he says, or I ask him, "Mr. Alexander, do you consider Mr. Gabriel to be among those Syrians who?" And he says, "I think he's a nice guy, but he's corrupt." So I say, "So you consider him to be a nice guy and corrupt?" "And corrupt, yes. You consider him to be corrupt on the basis of the evidence that you presented to the court, on what he has said to me, of what I know of him, of what I know his family is involved in, yes." And I say, "Good, and those things that you have just mentioned, are those things that you have mentioned contained in your written statement?" He says, "I don't know, I don't think so. Maybe it is, I'm not sure." The following page 980, at line 9, the things that led you to conclude that Andrew Gabriel is corrupt includes the things that you had in your mind on February the 8th that you have not disclosed to the court. He says yes. So again, we're coming back to the information that he has, and he's still maintaining that he's corrupt on the basis of information that he has not disclosed. And there's a last reference, because it did arise during the, in one passage from the Court of Appeal that I'll refer you to in a minute, if I have any time. At page 874, this is a cross-examination by Mr. Camacho on behalf of Mr. Alexander when he was representing Mr. Alexander. And he says, "Mr. Gabriel, you said that you would not accept an apology from Mr. Alexander. Do you stand by that?" And the answer is yes. And the trial judge had referred to that. That is the only reference to an apology in the entire transcript, if I may say. And that is what the trial judge was referring to when she said that Mr. Camacho had cheekily referred to an apology. And the Court of Appeal took that up in their judgment as one of the factors that they were taking into account when they were determining that only nominal damages was appropriate. And you will see that at paragraph 109 of the judgment, which is at page 1393. And the court says the suggestion of an apology was rejected by the trial judge as cheeky without exploring what the content of such apology could be. But there was no apology.
No.
There's never
No point speculating as to whether there could have been some sort of apology, because none was ever offered.
None was ever offered. And then they went on to speak about while a full apology might not have been possible, the appellant always maintained that he did not mean to refer to the respondent's parents. But I've just referred you to a passage where he's saying that it's corrupt because he knows what Mr. Gabriel and his family are involved in. So again, the Court of Appeal is proceeding on the basis of, a wrong premise, if I put this. The premise is that there was in fact an apology that was offered that was never explored. The fact is that there was never an apology. And the cheeky reference that the judge was referring to was that reference that Mr. Camacho says that I've just referred you to. So respectfully submit that having regard to all of those factors, to what Mr. Alexander's behavior during the course of the trial, to the widespread dissemination of the one defamatory statement that the court found was defamatory, to the serious nature of it because it went to the core attributes of Mr. Gabriel's personality, that this is not a case that warranted a nominal damages only of $10,000. It is therefore disproportionately low. And therefore, if this is the only aspect of the case that remains, this one defamatory statement, we respectfully submit that you ought to overturn the award and send it back for reassessment.
Thank you very much, Mr. Mendes.
Thank you very much, my lords, my lady.
Mr. Armourer.
Yes, my lords. I would like to announce that I have instructed me Ms. Anuradha Dean, and well, she has always been the instructing attorney in this matter. My lords, in my submission starts with identifying the issue that I think is the main issue in this matter, and it is that the Court of Appeal, this court, the Court of Appeal was firstly correct to set aside the High Court meanings arrived at by the High Court judge, because the meanings that the High Court judge arrived at were not achieved or reached by the correct route. In particular, no proper test was applied, and according to the case of Stocker and Stocker, that is one of the reasons, or one of the bases on which the meanings arrived at by a High Court judge can be set aside, and the
Why should we assume that the judge applied the wrong test? On the contrary, we should assume, shouldn't we, that the judge applied the correct test, not least because it was referred to in Mr. Mendez' submissions to the court, unless there's something to show that she didn't, and I can't see what that is at the moment.
Well, there is the paragraphs in the Court of Appeal decision that refer to the paragraphs in the High Court decision, which in turn show that the judge did not announce what test was being applied, and simply arrived at a meaning in respect of the first two statements, and it's made worse in respect of the 9 statements, because the 9 statements were all separate statements, and the High Court judge did not consider whether they should be put together or taken together and a meaning arrived at. And the Court of Appeal analyzed the High Court judge's decision, and I would like to be able to point out the places where that is dealt with. So I'll be going to my submissions. So in respect of the first statement, the Court of Appeal was able to identify that the High Court judge dealt with the first statement, and the High Court of Appeal dealt with that in paragraph 29 of the Court of Appeal decision, which is found at page 1361 of the electronic version of the electronic bundle.
Well, they're saying that her conclusion doesn't reveal these things, but that's just what I think they're saying, is that she didn't spell out the test that she was applying. I can't see that there's anything to suggest that she didn't apply the correct test.
Well,
and just took it as read because it was presented to her in submissions that weren't contradicted.
Well, my lord, my submission is that the context in which the words were considered in the judgment, we can go to paragraph, of the High Court decision where those statements were considered. Mm-hmm. And we will see that the High Court judge simply arrived at a meaning without applying a test. Unless a test is stated.
Well, was there any dispute as to what the test was between the parties before the trial judge?
Well, in the High Court, the appellant was the respondent was not represented at the stage when the decision was when submissions had to be made in respect of the decision. His counsel abandoned him before he was cross-examined, from what I remember. I was not there. And in terms of saying what test should be applied, the judge was accepting what was given by the appellant's counsel at that point, my lady.
But there was nothing, do you say there was anything wrong with the submission made by Mr. Mendes at that point as to what the law was?
What I'm saying is there isn't anything that says that the court, the High Court judge, actually applied the correct test. And the things that implied she didn't apply the correct test is that the stalker and stalker approach specifically says in respect of dealing with statements made on social media, the impressionistic approach should be taken, and the interpretation should not be one that is based on an over-analysis. So the quick impression that one gets from the reading of the different statements is the interpretation that one should put upon the statements, my lord. And one can tell from
I interrupt you for a moment, Mr. Ahmed? Stocker was a case where there was a question as to the meaning of the words used, whether the word strangle meant to grip by the neck or meant to try to kill by compressing the neck. And the judge in the case had gone to a dictionary to see what the dictionary definition was, and had, on that basis, adopted as a meaning, an attempt to kill. And the court said that that was a mistaken approach to go to a dictionary. The judge should be asking, how would the ordinary, reasonable person understand what was said in its context? As you say, the context was social media, and concluded that in context, the meaning of the word had been to grip the person by the neck. Now, in our case, was there any dispute as to is there any question as to what the words actually mean? I think is it not common ground that the sting, if you like, of the words is the implicit threat to disclose information which is of such gravity that the appellant and his family would have to leave the country?
The answer is yes, there is a dispute. The dispute is that the words were meant to be, on the part of the respondent, to be in the realm of verbal abuse in the political context. So both of them were posted or made on social media in the context of the respondent attempting to build himself as a politician and a political voice. And the actual words were slang and not susceptible to a dictionary or any plain English interpretation. So the expression bandit clan, as well as putting the files in the road, needed to be interpreted in the context, as the judge found, that this was she at points described him as garrulous and uncontrolled and ungovernable in the High Court judgment. And all of those things show that these were words being pronounced in an agitated, emotional state that were not meant to be taken seriously. And in the context, even here today, we heard that the interpretation of some of your lordships was that they were hard to understand. And
that's because we're not familiar with Trinidadian slang. That's why we need to have it explained to us.
But presumably he's speaking to his audience, and presumably he speaks to his audience assuming that they will understand what he's saying. We don't listen to him, but the people who do listen to him presumably want to hear what he says and understand what he says.
And it's exactly that the people listening to him would understand that he would be is speaking in extravagant terms that are meant to provoke thought and offend his political opponents, similar to calling, there's a case from, I think it was Australia or New Zealand, where on a political platform, somebody was described as vermin. And it was held that that type of word was subject to interpretation as to it was possible for it not to be defamatory. And so that is where the dispute was, the nature of the language as opposed to the meaning of the words.
But
So
can
for
you point to anything in the judge's judgment which indicates she wasn't applying the right test? It seems to me that she was. She refers, for example, to the ordinary reader in an age of social media in paragraph 26, who does not have to be avid for scandal. It suggests that she had consulted the authority that refers to you treat the ordinary person as not avid for scandal. I think that's an expression used in one of the cases.
yes,
It all suggests she had the right test in mind, as far as I can see.
well, in terms of that test, my lord, it certainly was not. There are points, I will deal with the Court of Appeal decision, my lord. So let me get that.
I know they said that she didn't show that she'd applied the right test, but as far as I could see, all that really amounts to is saying she didn't set out in her judgment so many words the test she applied before she went on and applied it.
Yeah.
Well, there's also what I referred to earlier, which was the taking of all the statements, of the 9 statements. Certainly the no test was applied in saying that those 9 statements were defamatory. It's simply an announcement.
No, but we're really interested in 1 and 2. I mean, number 8 or whichever it is has a peripheral role on aggravation, but it's not one of the part of the claim itself.
Yeah, when her references to the ordinary reader, not avid for scandal, it's a reference to the speech of Lord Reid in Lewis and the Daily Telegraph.
I'm not hearing your lordship.
So she has in mind the leading authority in the House of Lords on the test.
My lord, may I just
It's on page 1577.
of the High Court decision?
No, the relevant passage in the case of Lewis.
Well, what I was getting to, my lord, was the part in the Court of Appeal decision that identified that the High Court judge considered words out of context. So, for instance, in respect of the second statement and the reference to Bandit's clan, the Court of Appeal was able to identify that the High Court judge wrongly considered that second statement as being linked to the first.
Well, I don't think that's a fair criticism, because what I read she was doing was referring to matters not referred to in the first statement, was she, but in the post itself.
And in the post itself, the persons who are referred to are not the family members, but the other PNM and PNM adjacent persons, my lord. And in that sense, the
Oh, I see. The Bandit clan, you mean meaning the family? Yeah.
It does not refer to the family. And the analysis of the Court of Appeal was correct in that respect. I think I better just I will go. Okay. So, my lords, I will stick to my submission. So, going to paragraph 14 of my submissions, it is there that I point out that the High Court judge considered the first statement in paragraphs 15 to 20 of the High Court decision, and that can be found at pages 180 to 182 of the reproduced record of appeal.
So, do you accept that she accurately summarised the rival submissions by the claimant and the defendant in 17 and 18? Is that what they were saying about the meaning of the words in the first statement?
Well, that's what the High Court judge did. Yes, my lady. The problem is that the High Court judge should have, instead of approaching it in that way, have asked what impression would an impartial reader make of these posts, and the High Court judge instead simply repeated the tests or the interpretations that the claimant wanted and what the defendant wanted, and then came to a conclusion without saying that she was asking herself what impression would a reader of the words form? What impression would the reader of the words form? And so we have that conclusion being arrived at in paragraph 20. And the Court of Appeal did say that it was simply an announcement of a finding without an analysis, without the correct analysis being applied to it, my lords. My lord, I'm going to go to paragraphs 12, sorry, that's paragraph 29 of the Court of Appeal decision deals with how the High Court judge dealt with that first statement. And the question in my submission is it unfair, is it inaccurate to say that the conclusion arrived at in that paragraph 20 was arrived at without the application of a test? And I am saying yes, and that is because there is actually no statement that the judge was asking herself the correct question, and there's simply an announcement of a finding, and therefore I'm submitting that the Court of Appeal was correct in coming to that conclusion, and therefore correct in substituting for itself, by itself, its own meaning of the words. And I'm saying in particular that, well, I was relying on the Stocker and Stocker case. The similarity is that in Stocker, Lord, who was it?
Lord Kerr, I think.
Lord Kerr, yes, said that in the context of a mistake, an error of law, the Court of Appeal could reconsider the meaning that the High Court judge arrived at, and that is said in paragraph 50, let's get it, 51 of the Stocker and Stocker case. And I'm saying that the reasoning should be applied here. And the words that I'm emphasizing are, I emphasize again that it was a legal error on the part of the judge.
Sorry, could we have Mr. Armour, could we have a bundle reference to the Stocker passage that you're referring to?
My apologies. I will get it.
I think it's 1546.
Thank you.
The error that the judge committed in Stocker was that he didn't read the social media post in the way that any ordinary person would. He went off and got a dictionary and started looking up the definitions of the words in the post. And the point that Lord Kerr was making in that case was that you have to read it the way an ordinary person would, and that's not how they go about it. But I'm not quite sure what analogy there is with our case.
Well, the analogy is that this is a worse situation in that no test was applied and the judge simply announced a decision that is not justifiable in law by the application of a test. And
So, Mr. Armour, just on that, I just thought actually it's tolerably clear that the judge was applying a test. Because if you look at Mr. Mendes' written submissions at page 1007,
Exactly.
you get the citation of the relevant authority in Trinidad, which is Kayam Mohammed in Trinidad Publishing. But that goes through summarising relevant case law, including, as my Lord has pointed out, Lewis and Daily Telegraph. And you get there the summary of the tests of the person not being unduly suspicious, not avid for scandal, and so on. And one sees in the judgment itself that the judge has picked up that language. I mean, what other inference can be drawn but that she has followed the test that she was invited to apply by the claimant, not disputed by the defendant, and reflected in the language that she herself uses in her judgment? Isn't it clear?
well, I'm saying that it isn't reflected in the language in those paragraphs, my Lord.
Well, it is in paragraph 26 of her judgment. That shows, doesn't it, she was looking at it from the point of view of the ordinary reader.
And the claimant was saying this, what the ordinary reader would understand is X, and the defendant was saying what the ordinary reader would understand was Y, and she said she agreed it was X. But why do you think she's not applying the correct test?
Because the judge did not say it at that paragraph 20 when the finding was announced, when the meaning was announced, my lady. And in respect of 26, paragraph 26 of the High Court judgment, that of itself
Again, just to point out, she even puts avid for scandal in quotation marks. She's clearly quoting from something. What else could it be than Kayam Mohammed and Trinidad Publishing?
And she's also referred to the age of social media, which shows she's alert to the context of it as social media rather than any other form of communication.
My Lord, that shows that the judge had those expressions and words actually in mind, but as to the application of those words to the statement, we don't have the words being applied to the statement in the way in which I'm going to say that the way in which the usual analysis is applied to arriving at the meaning of words in a defamation case. So, for instance, in the Stocker case, the test is announced, then the test is applied, and then the meaning is arrived at as a result of the test being applied. Here, what we have is a situation of the meaning being arrived at, and then in a passing reference later on, there is a reference to words that come from the test, but they don't actually say that the test is what was applied. And then later on, we actually have the Court of Appeal making its own finding that the test was not applied. And the question is, to me, I'm submitting that the better view is that it isn't only for the reason that the test wasn't applied and it came afterwards, at least words contained in the test. There's also this pointing out that the words were not, when the analysis is applied to them.
Forgive me, I'm not sure that the Court of Appeal says that she didn't apply the test. We were looking at paragraph 29 in the Court of Appeal's judgment, page, well, in the key bundle 1363. I think it may be slightly different in the electronic. But the focus there, in relation to the first statement, is that the judge was wrong in her conclusion, rather than that she'd applied the wrong test.
Well, the next sentence literally says the conclusion itself does not reveal any examination of those words in their context. Neither does it reveal any analysis upon which the single meaning of those words by the reasonable, objective listener could be based. So it is stated there, my lord, right immediately, right after, that the Court of Appeal concluded that the High Court judge did not apply the test.
Well, forgive me, just to put the point again, it seems to me reading that paragraph, the Court of Appeal is not saying she didn't apply the right test, it's saying she came to the wrong conclusion, which is consistent with applying the right test. And then the question is just, did she reach a conclusion which wasn't within the band of reasonable conclusions that she could reach applying the right test? Is that not a fair reading of paragraph 29?
Not the part about doesn't reveal any analysis upon which the single meaning of those words could be based. So analysis definitely involves applying a test, my lord.
All right, thank you.
The error that, as they identify, the error they identify, I think, is in the last sentence of paragraph 29. They say it was an extreme interpretation by the trial judge to conclude that information which had not yet been revealed and which might not have been revealed was nevertheless so damning and damaging that the information could lower him in the estimation of right-thinking people. So they're focusing, the error I think they see is that the judge, instead of asking whether the threat to disclose information which was so serious that the family would have to leave the country, instead of asking whether that was damaging to reputation, the judge ought to have been focusing on the nature of the information itself. And because the information hadn't been revealed and might never be revealed, she couldn't reasonably conclude that the information could lower the claimants in the estimation, the appellant in the estimation of right-thinking people. I think that's what they're saying. So their focus isn't on the words actually used, but on the nature of the undisclosed information which was threatened to be revealed.
Yes, my lord. But it does start off by saying that the route to get to that conclusion was not the correct route that should have been used.
Yeah.
by applying any analysis to arrive at that conclusion, my lord. So in that sense, there is a finding that the High Court judge did not go along the correct route to arrive at a conclusion, and I submit that the Court of Appeal cannot be faulted for that, based on that High Court judgment. As I said, there is a repetition of the position of one side, then the position of another side, and then a conclusion. And then later on, in respect of the second statement, the Court of Appeal carried out a similar exercise, and the second statement was addressed
Well, I wonder, Mr. Armourer, if you're about to begin submissions about the second statement, we were planning to have a brief adjournment at this stage, so we could take that just now and hear you on the second statement when we resume in about 20 minutes. Would that be convenient?
that would be convenient, and I can assemble my thoughts and move more quickly. Yes, thank you.
Thank you very much. Well, that's what we'll do. We'll adjourn the court and resume in about 20 minutes' time.